Swayam Prabha. Digital India. Educated India.
Greetings to all the learners. So, we have discussed the salient features of the Electricity Act. We have looked into the statutory schemes of what on generation, on transmission, on distribution. We have also discussed that how the regulatory commissions are being entrusted with the necessary power to discharge the function, and also we have looked into the framework related to the appellate tribunal. Now, let us look at the proposed changes under the Electricity Act 2003. Now, in this discussion, I have included the changes which have been introduced or proposed to be introduced in the year 2020 and also in the current year 2021. The reason why I have identified and decided to discuss these two changes, so that we can understand the thought process of the government, and because the latest proposed amendment is also not tabled in the house on the floor of the house. There is no, legally speaking, there is no harm in discussing also 2020 proposed amendment, and that is the reason why I thought of discussing both in order to give the comprehensive overview on what has been going on in the mind of the government to bring in further reform in the electricity sector. And as all of us have been reading and learning through the news reports, that the state governments are protesting against the decision of the government to bring in amendment on certain areas. So, let us look at what were, let us try to understand that what were the reasons for the change, and then we will look at the salient features, and we will also try to analyze the possible impact of the same. The journey started in the year 2003, when the government decided to consolidate all the laws related to electricity and to give a new avatar dealing with the aspects of the power market. 2003 Act apparently appears to bring in necessary changes, apparently appears that it has successfully brought changes. It has contributed in the participation of private players in the generation segment. We see private players also showing interest in the transmission segment. We have learned that how professional, the issue of tariff determination has become, how the regulatory commission has been discharging responsibility in a transparent manner. So, overall it appears that the aim identified under 2003 Act has been achieved to a large extent. But 2003 Act cautiously decided not to introduce overhaul reform in the distribution segment, because of the very reason that distribution segment was and is still having a monopoly, state government governs the same, and then there are political factors which are in a way resisting the necessary reform in this segment. Perhaps in 2003 Act, it has been indicated that let the reform start gradually coming in, so that the benefit to the consumer be extended. So, in a way 2003 Act suggested for gradual reform in the distribution segment. That is how, when you look at the provisions on parallel licensing, when you look at the provisions of open access, it presents testimony of the same. But then the reality at the ground is different. Distribution segment has not been transformed, has not been liberalized, has not seen enough investment, and that is why these amendments were being proposed. These amendments were largely focusing on introducing the reform in the distribution segment. Additionally, it also attempts to rationalize the workload of the regulatory commission, because regulatory commission under 2003 Act has been entrusted with voluminous responsibility. It has to determine the tariff, it has to adjudicate the dispute, it has to time come up with a regulation. So, huge task was entrusted, and it was decided to rationalize that. It was decided to make the regulatory commission more professional, and in order to ensure the same, some of the functions of the regulatory commission was decided to be transferred on another body. And what was that function which thought of to be transferred? Was with regard to the enforcement of the contract, because when you look at the transaction, the nature of transaction in this sector, it is all about contract for supply and purchase of electricity. 2003 Act fails to deal with the aspect of obligation entered through a contract in a very effective manner. That what shall happen if contract is not been honored, whether we can have quicker remedy for the same. So, that aspect was considered and it was decided to introduce a new institution which shall be responsible for the contract enforcement. It has also been observed that regulatory commissions, the central one and the state one, they are discharging same function, but there are different selection committees for the same. And because of this, unnecessary bureaucratic hassles are coming. Longer duration is being witnessed for filling the vacancies. And that is why it was decided that let there be a single committee which shall recommend the suitable candidate for the tribunal and the regulatory commissions. Because of the absence of sector specific law to promote renewable, the government also proposed that the central government shall be responsible to formulate renewable energy policy. 2003 Act mandates the formulation of electricity policy and tariff policy, policy on rural electrification, but that does not categorically speak about renewable energy. There are scant references which we will be discussing at later point of time. So, it was decided that let there be a dedicated policy so that certainty will be better, certainty will be a kind of driving point for the investors to come in and contribute in the growth of green energy. With the integration of grid, as we have discussed and learned that we have achieved one nation, one grid goal, it has been observed that the activities at the grid level has gone up and there is a need of better coordination at the national level. There is a need of supervision, and that is why it was suggested to empower the National Load Dispatch Center. Cross subsidy has been a pressing issue under 2003 Act, as we have discussed that due to pressure from the obvious circle, the word eliminated was deleted and progressive reduction was introduced. So, instead of focusing directly on reduction of the cross subsidy, the government thought that why not to look at the tariff determination based on actual cost of supply. And when actual cost of supply will be a parameter for determining the tariff, then the subsidy part can be directly given to the consumer. And that is the reason why it was suggested that let the subsidy aspect not to be considered for the tariff determination. Let the beneficiary get the get the necessary benefit from the government through a direct benefit transfer scheme, and distribution segment should be given the necessary authority to determine to collect the charge, electricity charges as per the actual cost, and that is possible only when we have the tariff determination done without considering the subsidy. In order to promote green energy, it has been thought that renewable purchase obligation needs to be expanded, and in addition to solar, it has been also decided that hydro projects should also be considered. And long awaited reform to introduce competition in the distribution segment, the government thought of opening up the segment and enabling the consumer to identify the supplier. With the increase in the installed capacity of generation, now we have a surplus electricity. We have now necessary infrastructural arrangement in place to export electricity to the neighboring countries. Now, how it shall be done? Government said that let the Central Electricity Regulatory Commission also deal on these issues. So, let us look at how the amendment has been proposed. What are the proposed amendments? What government has suggested? So, it has been suggested that let there be a national renewable energy policy which the central government shall prepare after consulting the state government, and in that the idea would be to prescribe a minimum percentage of purchase of electricity from renewables, which obviously is the case even as on date where we have renewable purchase obligation. But through that it has been suggested that it is the central government which shall guide the RPO. As of now, it is the state commission which has been dealing with the same. There is a target which has been set, but under section 86 which we will be studying, it has been suggested that let the responsibility be there on the central government to ensure overall growth of renewable energy. On the lines of generation, it was decided to also de-license distribution activity. So, it was suggested that let there be no application to obtain license to engage into distribution activity under the Act. It is possible only with the registration. Registration by complying with the necessary norms which the commission would be prescribing. So, licensing has been replaced with the registration, and it was suggested that distribution licensee can very well ask another person to supply electricity, and for the same no separate registration is needed. So, franchisee, the system of franchisee was already there under the Electricity Act 2003. Distribution sub-licensee was introduced under 2021. Now, in addition to that, as I said that because of the increased capacity on the front of generation, because of the availability of generated electricity and supplemented by necessary growth of transmission network, now it is possible for evacuating the power from one part of the country and supplying it to another part of the country. And this very much relates with moving towards the direction of energy security. So there is an important task to coordinate. Under 2003 Act, Regional Load Dispatch Center is being made all powerful. Now it has been suggested that let National Load Dispatch Center be given the responsibility to do overall supervision and control. So NLDC in the proposed Act of 2020 suggested to be an apex body which shall be responsible for monitoring the grid operation and also for supervising and control the inter-regional and interstate transmission. So we have 5 region, and then inter-region NLDC will take care, interstate also NLDC will supervise and control. And then overall authority for carrying out real-time operation, because real-time operation is something which has been attempted to achieve, which means injection of power and evacuation of power is to be determined in a very meticulous way, in a very scientific way, so that there shall not be any waste. Infrastructure is to be used in an optimal manner. Proposed amendment empowered the NLDC to give necessary directions to RLDC and SLDCs, and non-compliance of the same would attract penalty. Looking into the functioning of the Regulatory Commission and in compliance with the direction of the Supreme Court in Users Association case, it has been suggested that there shall be a law member in the Regulatory Commission, so that whenever a bench is constituted, there will always be a law member to decide the issue. That is what it said. And in order to promote renewable, a stricter penalty was suggested for not meeting the renewable purchase obligation. Unrealized revenue has been a matter of concern for bulk supply. If you can recall, we have discussed that necessary regulation with regard to prepayment metering has been introduced, and that has been introduced in the retail sector. So in prepayment metering, no security is to be deposited. Now on the bulk supply, there is still a challenge to ensure the scaling of revenue and meeting the requirements which is needed for fulfilling the value chain system. And that is why it has been suggested that there shall be a legal mandate for payment security mechanism in the wholesale market, and load dispatch center shall ensure that before scheduling and dispatching the electricity. Cross subsidy, as I said, has been a matter of concern, and in order to tackle this issue apolitically in a larger interest of the electricity sector, it has been suggested that let it be aligned with the tariff policy, and we have learned that tariff policy, the formulation of tariff policy is the responsibility of the central government. Cross-border trade of electricity is been entrusted, the responsibility to formulate the guidelines has been entrusted to the Regulatory Commission, Central Electricity Regulatory Commission, and on the lines of reform introduced in other important public services, for example, food subsidy, fertilizer subsidy. It has been suggested that similar effort is to be made also in the power sector, where the government shall transfer the benefit directly to the beneficiaries. A new selection committee, single selection committee was suggested in 2020 amendment, which shall be chaired by a judge of the Supreme Court or a retired judge of the Supreme Court, and then we will have a nominated member from the central government and chief secretaries of the two states, and the chief secretaries of the state will be participating in alphabetical order of the name of the state. Another important change which was suggested in 2020 amendment is of segregation of the responsibility of the regulatory commission. The tariff determination would continue to be the responsibility of the regulatory commission, but as far as the contract enforcement is concerned, it has been suggested that let there be a separate authority, electricity contract enforcement authority, which shall be notified by the central government, and we shall have a sole jurisdiction to adjudicate upon the matter relating to the performance of the contract. This is for quicker disposal. This is for ensuring the necessary penal measures in case of failure to comply with the obligation. So, therefore, it has been suggested that any aggrieved person who is not satisfied with the performance of the contract, that person can approach the authority within 6 months, and authority should dispose it within 120 days. What shall be the composition of the authority? In 2020 amendment is suggested that there shall be a chairperson and then 2 or more judicial members or 3 or more technical members, and chairperson shall be either a sitting or a retired High Court judge, and judicial member shall be of the DJ or district judge or additional district judge rank with 7 years of experience. For technical member, it was suggested that the person must be secretary in the department of, in the Ministry of Power or the related infrastructural ministry, and having 1 year expertise, or then you can have technical member also from the domain expertise. Public policy has been a new criteria added under 2020 amendment. Tenure of the authority, the officials of the authority would be, the chairperson, the member would be of 67 years, with the the age of retirement would be 67 years, tenure would be 5 years with no reappointment on the lines of regulatory commissions. They would be asked to submit the resignation to the central government, and removal is also there, as it has been the case of appellate tribunal. The only thing is that when it comes to removal, the inquiry has to be made by the chairperson of the tribunal. The authority has been entrusted with the same power as it has been the case with the appellate tribunal, and they need to follow the same procedure which is there with the tribunal, meaning thereby that they are not court of law, so they are having necessary flexibility to conduct or carry on their proceedings. It has been said that the order of the authority shall be executable as a decree of court, and then it has all the power of the civil court, including attachment of the property or detention in prison of the decree debtor. That is what it says. Appeal against the decision of authority can lie before the tribunal to be filed within 60 days, and then it has been also suggested that tribunal, the members of the tribunal can be increased and to be made not less than 7. This is suggested considering the workload of the tribunal. Now, delicensing is an important step to reform this, important step to bring in reform to ensure that the consumer gets the choice, but then there is a very important issue to flag, and what is that? Whether it would lead to cherry picking, whether the distribution company will be more aggressive on supplying electricity to the industrial consumer, the commercial consumer, and would ignore the requirement of residential or agriculture consumer. So, that is a matter of concern, how that is going to get addressed. As I said, renewable purchase obligation is going to get shifted, because it is now suggested to be aligned with the tariff policy. So, central government will be determining the same. SERC to determine tariff without considering subsidy, that is what is an important change to be done in order to make DISCOMs financially more sound. The Regulatory Commission has been given an additional responsibility to adjudicate the disputes related to load dispatch center, because that is very obvious that with the robust network, there is a possibility of more number of disputes coming where load dispatch center would be involved, and therefore, Regulatory Commission has been given the necessary authority. In order to make the Regulatory Commission more powerful, the amendment is been proposed suggesting that Regulatory Commission's order will be executable as decree, and they will have the power of including the attaching the property or selling the property and up to the arrest of the person. It has been said that the proposed amendment is somewhere compromising with the federal structure, because we have learned that electricity is a subject falling under concurrent list, and therefore, due consultation has to be there with the state government. Now, the point is that whether state government has been consulted or not, whether consultation is effective or not, as we are reading the news, news report, learning from the different sources that some of the states are protesting against the same. So, how a subject matter which is there in the state concurrent list has to be handled, this case electricity reform in the electricity sector is going to suggest the future pathway in that matter, that how harmonization is to be there between the central and the state government. If some tough decisions are to be taken, how the central government shall be facilitated for taking those decisions, and how political economy will be considered, will be taken into account for not leaving the poor people at the mercy of the market. So, that is what is another important aspect to look at. These are the references for this session. Thank you very much.